Good morning, good afternoon, and good evening, wherever you are around the world, and welcome to our webinar on how to unlock the secrets to successful estate planning. I'm Mark McAllister, Senior Partner for Holborn Assets based here in Cape Town, and I'll be your MC today with today's excellent panel, who I'll introduce to you shortly. There is a section at the end of today's webinar for answering questions, and I would ask that you utilize the Q&A button at the bottom of the screen to type your questions as you think of them, and we'll do our best to collate them all and answer them at the end. But thank you all for listening and taking part. So let's get started. Let's begin with this very wise quote from Benjamin Franklin. In this world, nothing can be said to be certain except death and taxes. It's as true today as it was then. If the pandemic made you stop and think about our journey through life, you may be thinking about the delicate subject of passing on. And as professionals in this industry, we sadly and regularly see examples of the pain caused by poor estate planning and the very painful issues associated that can be approached pragmatically. Otherwise, your hard-earned wealth can be at risk. I'm very fortunate to be joined by an excellent group of speakers on today's panel with the subject of estate planning in mind, who will provide a huge insight into the do's and don'ts of how to unlock the key to passing wealth onto the next generation without the stress and cost of a complicated probate. So here are today's panelists. Firstly, from our team at Holborn Africa, Lourens Reichert, our managing partner, responsible for 7 offices across South Africa, Namibia, Mauritius, and heading a colleague count now of nearly 100 individuals across Africa. We are the most rapidly expanding division of our global international wealth management business. Joining Lourens is Martin Hall, director of Atla Group based in the Isle of Man. Atla are a world-renowned provider of trusts and pensions, and Martin's experience for helping clients all over the world will be invaluable today. Carl and Ken from Capital Legacy represent their specialist will writing and legacy business and will help explain the importance of wills and protection for clients with assets all over the world. So Lourens, Martin and Carl, thank you all for joining us today. Welcome to you all. Let me hand over to Lourens though to do the first part of our webinar. Lourens, over to you.
Hi there. Thank you very much, Mark. Thanks for the introduction, and hello, everybody. Thank you very much for joining, and also Martin, Carl, and Ken. Thanks for joining me today. So I want to start off with a story, and it's a sad one, but I think it's a good one to lead into our discussion today. So about a little over a year ago, a year and a half ago, my best friend, I knew her since she was 3 years old. My best friend drowned, and she had a partner, but she was not married, and she was a very successful IT business consultant, and she drowned, and her partner found her in the home swimming pool when she came home. You can imagine what this feels like for the partner who arrives at home. But an interesting thing about my friend is she spoke to the bank about setting up a will at my behest, I might add, but she never signed it. And so FNB did a will for her at her request. She never signed it though, and what happened was she died intestate. Now, when we speak to Carl and Ken, we can learn a little bit about what this means. But she died intestate, and she has an estranged brother she has not had a relationship with for a very long time, and she was not married to her gay partner. And South Africa has no laws that acknowledges the gay partner that she was with for many years was her fiance, and the intestate death meant everything that she owned went to the estranged brother. And you can imagine how this is for the partner who she was supporting. You can imagine how this feels. You can imagine the battle. And this is where I think the story is well Sorry, it's a bit emotional for me, but it's a good place to start. So I want to go over to Carl and to Ken to maybe educate us a little bit about what it means dying intestate versus having a proper will done, which so many people neglect. And I'll ask everybody on this Zoom call today, does anybody here know anybody alive that was born in 1900? And the answer is no, which means everybody's going to die. The thing is, we all think that we are going to live forever, and we don't, and we do not understand how pandemics, freak accidents, and the like comes for us, and it is never, ever planned on the day that we thought we would die. And I think that's probably a good place for Carl and Ken to educate us a little bit on dying with a proper will and what the consequences are of not having a proper will done, what happens, and how can these things be prevented. Gents, over to you.
Beautiful.
Thanks a lot, Lourens.
Ken, you want to jump in first, or are you happy for me to go on this?
No, I'm happy for you to go for it.
All right, fantastic. Lourens, thank you for that introduction. Sorry about hearing about your friend. And I think it's exactly that. So our company started 12 years ago because of this exact problem. The stats are horrendous. More than 75% of South Africans do not have a valid will. And what's even more shocking is only 10% of people who do have wills understand the cost of dying. So our initial mission here at Capital Legacy was purely to change the stats of the nation, which is why we draft wills for free. I mean, we're doing 15,000 wills a month. We purely wanted to make sure that every single South African has a will, a valid will for that matter. And during that process, and obviously, you know, after the pandemic and during the pandemic, it really came to the fore to us as to we needed to understand and change the perception amongst the population regarding wills. I mean, if you look in our Black and colored community in particular here in South Africa, those stats are even far worse. It's 95% of them don't have wills. It's just something that was culturally never ingrained. So it is our responsibility, you know, as advisors at Holborn, as Capital Legacy, being the leaders in wills and estates administration, to kind of impart with the knowledge and insights. And I'll tell you guys, so once a year, as many of you guys would know, the attorneys run what is called a Wills Week, which is when the Law Society of South Africa does wills for free for a week. And during this time, we run quite a few surveys out in the market to try and determine what is the reasons why, you know, people are not doing wills. And there are three popular answers to those surveys generally. The first one is that a will is a complicated document. Now, traditionally, it can be complicated if you're using a lawyer and there's a whole lot of Latin in there, but it doesn't need to be complicated. Secondly, is that it's a very expensive document. Again, we know it doesn't need to be expensive, or there shouldn't even be a cost for getting a will done, right? And then thirdly, and Lourens, you mentioned this in your opening, that people in South Africa in particular have this kind of Teflon Don kind of persona about them, that nothing's going to happen. And I think with the pandemic and with, you know, the way the country is at the moment, I think that has truly come to the fore. You know, we've never seen as much business come to us, so we are fortunate in that way. But it's terrible that it's taken a pandemic. It's taken people losing, you know, friends and loved ones that they never expected to lose now, for them to realize the importance of having a will. And in South Africa, we do have freedom of testation, and I think we take it for granted. Many civil jurisdiction countries, Portugal, Spain, the Francophone countries, Mauritius, the Arab nations, Middle East, you don't have freedom of testation. You don't get to dictate, you know, what happens to your estate at 100% of it. In South Africa, we've got that freedom. And we need to use that and get a valid will drafted. You mentioned interstate succession. So, I mean, we deal with it every single day. You know, if you don't provide your family with certainty, and it's quite upsetting, because we have these meetings with families when we administer estates, and the reality is that people mourn family members' deaths for about 2 weeks until it's time to go over the assets and you know, who gets what. Then everybody's fighting. Then everybody forgets about, you know, the person that's worked their entire life to leave this legacy behind. And it's our responsibility. It's our responsibility as the market leaders in the will space it's the responsibilities of advisors that we work with, such as at Holborn, to make sure that, all good financial planning starts off with a will. You do everything else in between. You do your risk planning, you do your wealth creation and wealth management in between, but you start off with the will and you end off with the certainty of estate administration. And that's what we do here at Capital Legacy, because if you don't give your family that certainty, as I said, we're doing thousands of estate every single year. And our estate administration process is a very bespoke process where we sit with clients face to face. So you don't deal over the phone with heirs. You get to see them after they've lost someone that they truly love. And it's quite shocking to see how quickly they forget that person, and everybody starts squabbling for, the house, the assets. So, if there's one thing that I can tell everybody that's on this webinar today, it really shouldn't cost you anything to get your will drafted. Get it drafted, make sure that it's valid, follow the particular guidelines to make sure that it's valid, and make sure that it's in safe custody. And because at the end of the day, I think for me, as a regional manager for Capital Legacy, what kills my soul is when I see a client of ours that has passed away, and I got into my system and I see that we've drafted a will for them, but we've never chased up, the signed will. We've never made sure that it's valid. And that's why we, a couple of years ago, we pivoted as a business to actually measure our staff with how many signed valid wills we get back into safe custody. It's not about how many wills we draft anymore. It's truly about how many are valid, how many are in safe custody, because at the end of the day, that's what counts. What is executable? What can you take through to the masters? Already in South Africa, in a lot of the smaller kind of municipalities, as many of you guys would know, those are delinquent municipalities. You kind of rely on the big metro areas to kind of carry the estate, the master's offices across the country. So at the very least, make sure that you've got a valid, clear, executable will. Stay away from complicated bequests. Some things that we see on wills are rather ridiculous. People wanting to put, a 10-year-old vehicle into a trust, for example. I think good advice, making sure that you start off by getting a will done, that it's properly validated, that it's in safe custody, I think is step one to truly making and leaving a lasting legacy behind. That makes every other process during the estate administration journey a lot easier, because there's many other challenges that we have to deal with, whether it's deeds officers, whether it's SARS officers, when people have firearms, when people are based offshore, for example, if they've got offshore beneficiaries. So there are so many challenges that we can unpack when it comes to estate administration, and in your space in particular, Lourens. But yes, Ken, I don't know if you want to add something, but looking forward to engaging with everybody.
Yeah, so I mean, I'm going to reiterate what Carl said. I mean, the importance of a will is so up there, and it's part of the first thing in planning for anything. I mean, in your story, Lourens, I mean, unfortunately, your friend passed away without a will, and that causes big problems. Like Carl said, in South Africa, we have freedom of testation, so we can actually direct how we want our estates to be distributed. In your friend's case, it would have been to her partner that it would have gone. When it comes to intestate succession, unfortunately, you don't have that right anymore. You've basically given up that right to direct how you want your estate to be distributed, and it then goes in terms of the Intestate Succession Act, in which case, it's predetermined heirs that follows your family bloodline kind of thing. So it bypasses that. Luckily, we have had a very, very recent change in legislation, which unfortunately happened after your friend's passing, where they actually now do recognize a life partner as a spouse in terms of both Maintenance of Surviving Spouses Act as well as the Intestate Succession Act, so long as there was reciprocal duties between partners. So if that had happened before, it would have been a lot easier, but unfortunately, it probably wouldn't have been the entire estate that went to the partner as the intention most probably would have been. Whereas having a valid signed will in place and having a testate estate means that your estate gets distributed to who you want it to get distributed to. It gets administered by people that you can trust. With your friend, it would have been, running around rattling to find an executor to actually do the administration as well. Having your will in place puts all of that in place. And it's the same for individuals, where there's minor children involved. Nominating a guardian for that minor child, it puts all those provisions in place. So it's extremely important. And it is part of the first thing. And I mean, especially when you've got assets worldwide, then it's very, very different. You've got to make sure that your will caters for those different jurisdictions that you have assets, that it can speak to how you want those assets to be distributed and sorted out. So yeah, back to Carl's point, very, very important. It's the number one thing.
So if we go over to Martin, and who sits in the Isle of Man, Martin, do you see such a big emphasis on wills in foreign jurisdictions as much as we place it here in South Africa?
Yeah, for sure. It's interesting listening to the guys, I suppose, South African side. I suppose from a trust base, we often come in as a sort of second phase of maybe that either international assets that they have internationally. But ultimately, often the first conversation we have when we talk about trust with clients is, have you got a will domestically, and how are you dealing with your assets that you're keeping in your own name? So yeah, again, that's a very early conversation, and I'd reiterate, and same with legislation in the Isle of Man, having that will and that freedom to pass assets on. It's a freedom that many countries crave and that we often so easily neglect.
Yeah. So okay, I think the point has been really well made by both Ken, Carl, Martin about, okay, we need a will. And I already saw one or two questions on the panel. It's not just about who is the who's the will writer, but it's also who gets to execute that will, and the cost associated with executorship, etc. Now, what most people do is they think they get around cost by naming a family member as an executor. So Ken, I'm going to come to you just very quickly. So if someone just asks a family member to be an executor of an estate, what is the likelihood of them getting away from any cost to execute that estate?
Very, very little chance of them getting away. So the problem is your executor has the duty to wind up the estates, and that includes drafting the liquidation and distribution accounts, doing the final taxes, going to the master's office to report that estate. A lay person like a family member isn't going to know how to do a distribution account. They're not going to know how to do a liquidation account. They're not going to know how to do the final taxes, being the CGT, because when you pass away, you're deemed to have disposed of your estate at that date. So it gives rise to capital gains tax. So there's all these things. So ultimately, that person has to go appoint agents, being accountants, to do the final taxes, appoint an agent to go into the master's office, appoint an agent, and all of those agents start charging, and those fees start racking up. And that's where you're never going to get away from the costs, unfortunately. It's just as simple as that.
Okay, and gents, who can talk to me a little bit about power of attorney? So I've had an unfortunate event happen not long ago where a client said to me, my husband, who is the main holder of our assets, he's got early onset dementia. So how important is a power of attorney for family members or spouses, etc., to have, or in the case of a trust, Martin, how important is it to have power of attorney when spouses can become not corpus mentis, that something can happen, they can't be of clear thought. What maybe Martin, we can start with you. How important is it for people not just to have wills and letter of wishes, but also powers of attorney with nearest and dearest?
Yeah, absolutely. If I could just finish off on the previous point, that appointment of executors, and I think a really important part is outside of the cost, I think, and again, kind of stepping on the will experts' toes, but one of the experiences we have on the trust side is having someone independent to execute that will, because unfortunately, often money creates disputes, whether it's written in black and white or not. So having that independent professional executor of that will we see it in the trust space, that independence adds real value to ultimately the person who's passed away and wants their assets to go down a certain route. So when it comes to power of attorneys, we do see them. So if we're setting up trust structures, we're setting up pension structures, we have a line of communication with the clients. They're looking for, and we obviously get to know that client and understand their needs and requirements. But over time, if there is incapacity issues, what we don't have is that almost weekly interaction, unless it's a really active client, that weekly interaction. So that client's wishes and needs change. So if there's a moment when they become incapacitated, and we haven't got that close interaction with them, then without that power of attorney, that kind of line's just gone in regard to communication. So they have a power of attorney in let's say, with South Africa, and it was their spouse. We're presented with a copy of that, and immediately the communication lines, that they've got that connection. They know the story, they know the client's wishes and needs. That communication line can open up immediately with the spouse just by getting a copy of that power of attorney. So certainly from an international market, having that domestically is, I think, very important.
Thank you, Martin. Fantastic insight as always. Ladies and gentlemen, we're going to be launching a poll shortly, so please feel free to answer the questions. We'll be sharing the results towards the end of the Q&A session. Always great to get an insight to the people that are listening, whether you're in a similar position to the majority or the minority. So we'll feedback on that as we go. So one of the things we want to try and do today is deal with the sort of top 5 commonly asked questions. We've touched on some of them already. So the message I think we're getting from all of our experts is, look, if you're listening now and you haven't got a will at all, urgent action is required. Let's get at least a will in place. And I think one of the questions we've got about the concerns about any kind of costs or whatever is a discussion to have with a financial planner and professional will planner. But in the absence of anything, get a will put in place, and Capital Legacy are a fantastic business for doing that we work well with. And then once we've sort of established that, so if you sat here, you're going to go and get your will sorted out, just get that bit done if nothing else. There's like a layer above that, which is, we've got an asset base that's maybe larger. We've been working hard all the way through our lives, and we've accumulated, let's say, a nominal figure of 10 million Rand for argument's sake. So let's start off with that as 10 million Rands just in South Africa. Guys, just walk us through the Estate Duty Act in South Africa. If we had a client that had a load of assets, maybe a property, maybe some stocks and shares, maybe some other bits and pieces of investment property, things like that. What should somebody be thinking about if all of those assets are owned by them personally in South Africa with an estate of that sort of value? What's your thoughts on estate duty there? Maybe Ken.
Yes, so I mean, our Estate Duty Act, your first 3.5 million Rand worth of your assets is deducted for estate duty purposes. Anything over that, you're subject to 20% estate duty. So an asset base like that, you're definitely going to give rise to estate duty, unless, of course, you leave it to your surviving spouse, in which case, anything left to a surviving spouse is also deducted from estate duty. But it means that ultimately on second dying, there's going to be that estate duty implication in the surviving spouse's estate.
Okay, fantastic. So generally speaking, then, if somebody's got assets north of that estate duty line, so let's say typically most families that we interact with, there's normally a couple. So let's say 7 million Rand. So if somebody's got more than 7 million Rand, and maybe significantly more than that, let's say double that, let's go 15 million above, are those the kind of clients that maybe should consider whether they should own all of their assets personally, or maybe is it time, particularly if the age profile is right, to start considering wealth management tools, the likes of offshore trusts, local trusts, pensions, that sort of thing? Is that the kind of thing that you think would be worthwhile to consider, Ken?
Yeah, absolutely. I mean, the moment you've got that north of 7 million Rand, you should definitely start looking at some kind of structures where you're not holding the assets personally in your name and the wealth isn't grown in your personal estates. And it's actually growing in some kind of structure that's not going to give rise to estate duty on you passing, because it's a separate entity completely, and you passing away has no effect on the assets therein. So definitely, when you've got assets of that value, you definitely need to start looking at some sort of a structure.
Okay, fantastic. Okay, moving on, next sort of question, and it's very interesting. We've got the poll running in the background. Thank you to the 54% of our attendees today that have already answered those questions. Please do add your feedback, and we'll go through them. One of the questions I'm going to sort of launch straight into, over half, actually nearly 60% have answered so far, have assets in more than one country. And this is probably something that we find as the financial planners, that we are often, particularly Holborn, with our experience, we focus very much on assets outside of South Africa. We're able to assist locally as well, but we do a lot of structuring, a lot of investment management outside of South Africa. Might have heard my favorite strap line, which is, invest where it's cold, but live where it's warm. So let's say we've got a client that maybe has, been abroad, they've got a load of assets, and say UK is quite common. They're back in South Africa listening to this webinar now. What's the kind of things that they should be thinking about Maybe Lourens, I'll start with you on that. If you were having that conversation as the wealth planner, with the client, what's the kind of things that you would be encouraging them to think about, and then maybe where the solutions that these guys often fit in?
Well, Mark, the conversation definitely turns to a more technical nature where you need proper wealth management now. Just a will on its own is not going to relieve you of a couple of things. So let's take your client, for example, that have assets more than one country. Let's say, for example, the problem is it's not just clients that have assets in more than one country, they have kids in other countries. And then it becomes very tricky. So let's say your client, for example, to give you an idea, let's say your client had more as a combined spousal pair, more than £650,000 worth of UK assets. They've got a UK Situs problem of 40%. If they have more than $60,000 US worth of property in the US, they've got a US 40% Situs problem. They have a South African 20 or sometimes 25% estate duty problem. But let's say they have kids in Germany, just for example. If they have kids in Germany, they have got estate duty in the US, or not estate duty, they've got inheritance tax in the US, they've got inheritance tax in the UK, they've got South Africa that they need to contend with. But in Germany, they don't tax the estate, they tax the person who inherited. And then they have a 20 to 25% problem. I mean, their estate can get wiped out. But now, interesting thing is, as Ken rightly pointed out, and I'm going to lean on Martin for this one, but you should look at jurisdictional planning specific for that jurisdiction. Because if you bang everything in a trust, the UK might not look favorable on that trust. For example, South Africa might think that you need loan accounts in that trust, but the UK might want to charge inheritance tax on a 10-year basis with that particular trust. So you have to start navigating the world of trusts, pensions, life cover, companies, sometimes all sorts of interesting things that you have to cover. Martin, I know that you deal with this on a daily basis, but in Mark's example of a client that have UK assets that have moved to South Africa, what is typically the sort of traffic that you see in that direction?
I'm still reeling from his comment that it's cold in the Isle of Man, to be honest. You're right. It's planning and advice is the most important thing. So certainly the UK, that's they've clamped down and brought in a lot of restrictions about holding assets internationally, but it's achievable. Again, it's about the advice. So we sometimes see pension planning around, certainly the IHT problem for UK assets. Again, the profile of the client has to be right, circumstances for the client's future plans have to be right, and access and needs and requirements. But again, it's just again important to lean on the professional and the advisors around them to and then bring us into that conversation to steer the ship through the right sort of pathways. None of it, although it can be daunting at the outset, it's probably not as daunting as the potential IHT liability somewhere down the road.
Thank you, Martin. As always, an interesting take on a very complex area. One of the polls that we're running today, do you have a will which specifically covers each jurisdiction where you have assets? So we now have 62% have answered that question. Interestingly, 46% think they do, but 46% no, they don't, and 8% I'm not sure. So one of the things that we quite commonly come up against is wills that are written for, say, just the UK and maybe doesn't even take into account anything going elsewhere, or sometimes a will that's written with a well-meaning paragraph that removes, the rights of any previous will that's been written, so renouncing a previous will. So guys from Capital Legacy, can you just maybe guide us through some of the common issues that you often see with this sort of cross-border assets issue and things that you would encourage people to think about?
Yeah, sure. So, I mean, I think one of the biggest things is actually one thing that you mentioned there is that accidental revocation. You have a will done in the UK, you have a will done in South Africa, but the will in the UK says, I revoke all previous wills done by me. And it accidentally revokes your South African will, but now it's only dealing with the UK. So that's one of the biggest things that we do see. And I mean, we do something called a worldwide will, which, although it says worldwide will, doesn't cater for every jurisdiction in the world, because you do get your civil law countries and your religious law countries. But for common law countries, it actually can cater for those. And that's where it's quite nice, because there's no chance of accidental revocation or any chance of a clause being accidentally revoked in terms of that will. It also makes it quite nice from a seamless point of view. Although two wills, if you have a foreign will and a South African will, for instance, they can run seamlessly together at the same time. Having one will, done in South Africa as a worldwide will, we merely get it sealed by the Master of the High Court when reporting the estate here, and then send it offshore to get a grant of probate from the probate courts. So it is quite important when you're having more than one will done to make sure that they don't revoke each other.
Fantastic, and really interesting stats coming in now, guys. So we're going to try and steer the conversation this way. So 82% of those that have answered so far are based in South Africa. A few other sort of jurisdictions dotted around. And do you have assets in more than one country? 60-odd%. So I think we're leaning this very much towards a cross-border chat, focused on South Africans. To fit in with that, I've got some live questions coming in here. Firstly, from Penny. Let's do our best to try and answer this one. So I considered creating a trust for my grandchildren in my will, but I do not like the cost emanating from the management thereof. An inter vivos trust is just as expensive to manage, and there are so many tax implications. What is the alternative? Interesting question, maybe a little bit technical, but Ken, let's start with you.
Sure. So yeah, unfortunately, trusts are expensive, and from a tax point of view, they're actually really horrible in South Africa. Trusts are the most highly taxed vehicle in South Africa. Unfortunately, they're the best vehicle for protection of assets and looking after children. For grandchildren, for instance, they're actually treated very, very favorably. They're seen as a type B special trust, where they're taxed as an individual. But yeah, you're absolutely correct. You're still going to have those costs of having a trustee on. And you do want, same as Martin alluded to earlier, you want that professional independent trustee on in order to manage it properly, make sure that all the compliance is done correctly, not run away with the money, that kind of thing. But it is still the best structure to utilize is a trust.
Okay, and that's interesting. Sorry, Lourens. Just think connecting what you were about to say there. So a local trust, we've identified it works, but it's maybe quite heavily taxed and not as efficient as they used to be. A lot of people on the call looking at international trusts and pensions, those kind of solutions that we're probably going to move on to now. Lourens, I mean, obviously we have these discussions all day, every day with clients. When would you start thinking about using an international trust or an international pension for a client?
Just before I go around that corner, I just want to come back to Ken's corner, but and maybe Carl, because you're too quiet for my liking. Maybe Carl can, but then bear in mind we have a time limit on the webinar, so when you get going, cut it short. But so one thing that Capital Legacy does is providing a small insurance policy. They provide a very tiny little policy that can pay for the very big trust later. Do you want to just cover that very quickly, Carl? Because I think, Henny, this might sort the queries that you have around the fees of trust later down the line if you pass away.
Beautiful, Lourens. Absolutely. I'll keep it sweet and short. Yes, we do have a product called a legacy protection plan that accompanies our clients' wills. That product is purely there to assist clients through the pitfalls that we've uncovered during, administrating these estates now, doing over 6,000 estates over the past 5 years. That includes covering your executive fee, which is regulated at 3.5 plus VAT of 4%. If you own properties, it covers the conveyancing of those properties, so transferring it into the new owner's name. And then, of course, trusts. So in the legacy protection plan's case, we're obviously looking at testamentary trusts, which are set up at death, because the alternative is if you want a minor child to inherit, it goes to the government's guardians fund. And, seeing that 82% of people are in South Africa, I don't know how many of you want to give the government any money to oversee for your children. So what we actually do at the point of consultation is do a calculation, how much assets are going into the trust, how long do you want those trusts to run for, is the vesting age 25, or if it's a special needs child, it might be 50, 60 years, which will generally erode the assets within that trust completely. That small insurance product, I mean, it's relatively inexpensive with an average cost of 150 Rand, covers all of the legal fees, including the trust setup cost and annual administration of those trusts.
And just give a headline figure. How much do these things cost on average for any sake?
Well, it really depends. So, I mean, generally, most people want to set up testamentary trusts, which, let's say, in my case, I've got a 10-year-old son. I wanted to run for 15 years. If something happened to me today, that will cost about R500,000 during the term. And for any kind of normal person, that is a lot of money that is simply going away towards administration of that trust. Now, of course, in my case, I've got a protection plan covering all of those fees, which means not a cent of my assets within that trust gets touched. So when my child gets to the vesting age, he gets the full assets plus the growth.
Cool. Okay, so Mark, if I can now go around the corner to your question. Yes, the offshore planning component, mainly the biggest thing is a South African trust cannot be the owner of a true offshore asset. It can asset swap or whatever the case might be, but it cannot be a true offshore owner of an asset. So you have to go to the offshore world. Now, you have to be sensitive to certain tax consequences as well. So, for example, there is no easy entry into a trust from a South African perspective. You're either going to lose your shirt on donations, or you're going to have to structure it via loan agreement. And the loan agreement is an interest-bearing loan agreement, and interest rates are not kind overseas at the moment. So it's not a cheap affair. However, that's kind of where the problems with trusts kind of die, because if you set it up in Martin's backyard or in places like Jersey or Guernsey, well, then the trust is resident in that country for tax, and it does not pay. Well, it does pay. It pays 0% tax on all its gains. It actually fills in a tax return at zero. It's kind of funny, but also it then leaves those assets outside of the estate. Sure, a loan account might still be in your estate, but all the growth sits outside. So they are marvelous vehicles to utilize. And Martin, I have been asked a question, and I'll come to you. One of the biggest drawbacks of trusts is not actually, in our opinion, the fact that they can only be funded by a loan account. Our biggest, what I would say, objection is the trustees can run away with my money. I've heard this so many times. In South Africa, they'll set up 200 trusts because everybody here can settle a trust and be a trustee on their own trust, bizarrely. But overseas, oh no, God, I'm going to give this to a professional body and they can run away with my money. What protection does a client have if they set up an overseas trust?
Yeah, no, look, we get asked that question a reasonable amount of time, and it's a reasonable question to ask as well. So there's various layers, and we see my expertise is on the Isle of Man here. So I particularly talk about the Isle of Man. We've got a regulated space, so everyone within. So Atla as a business is regulated. So again, our regulator will come in essence, audit us from an external point of view. We have to have PI cover to a level. So again, if we ran off into the I was going to say into the sun, but we're here already, into the winter somewhere, there's still ultimately claim against our PI. And again, obviously that's a very worst case scenario. And then people within the business have to be regulated and approved key persons. So again, our regulator will vet the people working within the business. And then you go to kind of lower levels of security around. Obviously, you can complain to the regulator and they can come and slap us around. The ombudsman on the Isle of Man can do that as well. And overriding all of that really softly, but as a business, you do that, your reputation's gone. So the reality is that there isn't really stories of that happening nowadays. The regulation's just too high and tight now. While that's very ultimately that has to be balanced with. You touched on fees for local trusts internationally. They are in a slightly higher bracket, but the reality is you're paying for that through the governance and compliance that our regulator has over ourselves and the industry here. But perhaps that small, medium-sized extra cost is ultimately providing that security for the clients. And what I would add, just to the conversation you were talking a moment ago about the tax-neutral jurisdictions. So entities here, like you say, there's no tax leakage with zero rate tax. What I'd also add is, and you touched on earlier about perhaps family relatives that are in Germany, another one in America. When you've got structures offshore, all you need to think about is the end taxation points primarily of distributions. Once it's in the Isle of Man, you don't need to really think, well, my children be in 15 years' time, does that affect where my trust is? Stick it in the Isle of Man, it's tax neutral, worry about where the child is or the adult by the time you're making distributions down the road. So it just provides a hub that's tax neutral, other than you may have some tax points you touched on. If you've got UK assets, there may be some matters. And again, the professionals can walk you through that side of it.
Fantastic. Thank you, Martin. One of the questions that we asked today was in relation to utilization of estate planning tools. So currently 71% of the people listening today haven't considered or don't use estate planning tools. So if you're one of those 71%, and your assets, as we were saying earlier, are north of that 7 million rand threshold, then it's something you really should be considering. You most certainly should be considering at least a will as a basic layer of protection. And in the solutions, 19% have a local South African trust, so maybe butting it up against the kind of challenges that we were chatting about earlier there. Interestingly, only 26% in international solutions, so 10% using offshore trusts. And then here's the one that everyone sort of misses, or probably the most misunderstood solution, I would say, in the wealth planning space: offshore pensions. So these are maybe offshore pensions that someone's accumulated working overseas, but also I imagine within that are those that have funds that they've taken out of South Africa internationally and put into an offshore pension vehicle. So Lourens, this really is your area of key expertise. When would somebody want to consider an offshore pension? And then maybe we can move over to Martin afterwards to talk through the structure of that.
I'll preface this by saying they are probably the most hotly contested vehicles on anybody's radar, depending on which side of the aisle you sit. But they're only contested on what everybody's view is in terms of their taxation. That's the only question mark that exists around them. We don't really have legislation that covers a full offshore pension that's held by a discretionary trustee overseas. So we kind of have to navigate around our Income Tax Act to really find out how people view these things. SARS has recently brought out a BCR notice on some offshore pension that was set up by a local business. And whilst it did say that the pension assets were property of the estate, I was okay with that, actually, if you utilize that vehicle, because you get a whole host of other benefits. Because the thing is that we have something in our income tax sort of law, which is called GAR, the General Anti-Avoidance Rules. And if you are going to do anything, it doesn't matter what it is, if you do anything to avoid tax, it's kind of a linear line of questioning. Mr. and Mrs. Klein, did you get a tax benefit by doing what you did? And if the answer is yes, okay. Well, did you do it to get that tax benefit? Well, yes. Well, then we just tax it as if it's yours. So tax should be an accidental benefit when you do anything. So let's start with saying that. But after that, now let's go into the international pension planning space. I think this is a wonderful place to plan. And I tell you why, is because when Martin has to set up a trust for a client, he has to set it up individual deed for that particular client. And that's going to come with its own cost. But when they set up a group pension, they create one deed for all the pensions, which means the pension costs could be segregated much like the deed is. So the first thing to say is, well, an offshore trust is going to cost you $3,000, $4,000, $5,000, $6,000, $7,000 a year to maintain, when a pension is $1,000 or $2,000, depending on quantum, of course, but it's $1,000 or $2,000. It could be a fraction of the cost. So costs first is the big one. And what is also very, very, very unique about this recent ruling from SARS is it agrees with all of our thinking that there's no donations tax to an offshore pension. This is crucial because if there is no donations tax, it means we don't have to loan assets in. And again, think about a trust. If I loan a trust money and it has to pay me back at LIBOR +1, now it's paying me back 6% a year. If I put in $1 million and it has to pay me back, say $6,000 a year, or sorry, $60,000 a year, then it's going to hurt, because I'm going to have to pay income on that income tax on that $60,000. So my trust cost me 5, but the actual income that I'm generating from the trust interest is costing me another 30. And so that becomes a very expensive exercise. On the converse side, if you have a pension and it's clear to all of us that there's no donations tax going into these vehicles, regardless of whether they mitigate the estate duty or not, that's not the question. It means that the cost associated with it is so much lower. So that's, I think, the first thing. And then both trust and pension grow in a zero tax environment. And all the benefits apply. Your base capital is where you start. You can draw your base capital out. So it's a wonderful planning vehicle, in my opinion, and it just edges out from a South African planning perspective. Certainly, it edges out a trust, mainly because of high interest rate and loan accounts. Do they have drawbacks? Yes, they have drawbacks. One is the law is very, very clear around trusts. We don't have to worry about, it's a little bit still of a question mark, like, what are these things? I'm kind of hoping that our revenue regulator kind of gets its arse in gear and actually do legislate. Then we all know. So we're a little bit slightly in the dark as to, we have to get senior counsel legal opinion to navigate this with clients, rather than just have the South African Revenue Authority blanket statement on it. That would be better. But in general, I think they're great planning vehicles. But again, they should not be abused. So if you've got someone with mega estate, okay, so let's say someone is worth, I don't know, 10, 20, 30 million US. Okay, if they pump everything into a pension, they're going to have to justify that they are going to draw all of those assets out as a pension. It might be difficult to justify, I think. So you've got to be careful with just pumping everything into pension. Do human beings pump absolutely everything they have into pensions? Probably not. They hold homes, they hold pensions, they hold various different things. They have trusts. So you kind of have to have a little bit of everything, I think. And I think the final point is, as long as the intentions are right, which is full quid pro quo. I put my money into that pension. It is my intention to draw that money out again over my lifetime. I think you're right as rain. If the idea is to subvert the wheels of justice in somehow, to escape, I think it's the wrong way of planning. But I think our suitability report for clients will always demonstrate that. But yeah, that would be my 75 seconds on pensions.
Great stuff. And Martin, let me bring you in then as a key provider of offshore pensions for South Africans. So let's say we had a high net worth individual. We'd identified that they could do with a primary currency vehicle. Predominantly, that's the main reason that these sort of discussions come about. Holding rands for everything isn't necessarily something that all clients believe in South Africa anymore. I think the recent dip in the rand yet again, the issues with Eskom yet again, the list goes on and on. So what are the kind of things that you think South African clients that you deal with are looking for in the international trust, international pension space in particular?
Yeah, so I think one of the things you mentioned there, diversity is super important in any scope, whether it's domestically with your assets or internationally. So the pension can help provide that in not only in currency but obviously in asset class as well. I think the other thing that was just touched on there was or not touched on, but was part of the thought process is within a pension plan as well, there can be a wide investment class. Again, I think typically there's a thought process that pensions can be very low risk, which typically is what you want if it's a longer. But typically, because it's a longer term investment, you can often find, and it's easier to get a longer term exposure. And again, that's dealing with the advisors such as yourselves and the client to ensure we meet their horizon. And just touch on a couple of points Lourens mentioned there. The effectiveness of keeping it simple, and he's dead right that the pension scheme, ultimately an international pension scheme, is really simple. We've got this master scheme. They've got segregated pots, so there's a problem with one person's liquidity, it doesn't affect anyone else's. But that ability to, in essence, bolt them together brings that cost right down. And again, similar to the conversation earlier, it's tax neutral when it comes to pensions on the Isle of Man. So the only consideration is distribution time further down the road. Where's the beneficiary sat, and they just need to think about their tax position. So yeah, externalizing it all. And I think you touched on when you introduced this question, if they've got assets already abroad, sticking it in a pension, the suitability report that you guys can provide to support that contribution level. And again, I think it's important for anyone listening, if they're dealing with pension providers, pension providers should also be questioning, is the suitability right? Is the extended time, or is the client's age right to be doing pensions? Is the amount, as Lourens touched on, going in correct? Because again, a diligent trustee of a pension should be asking those right questions.
Fantastic. Thank you, Martin. Still trying to get through as many questions as possible. Really shows actually the importance of this discussion when you look at question 5 on our poll today. Do you feel like your assets are sufficiently protected from unnecessary taxation when you die? 2/3 say no. So again, I always say with clients that this kind of discussion normally is just below cleaning the bathroom about the second time this week. We don't really prioritize it. We'll get around to it at some point in the future, and then the unfortunate happens. But it is an important thing to think about. Okay, so we've already talked about now the basic, the foundations in the ground, the cement in the ground has to be a will. Everyone should have a will. Okay. Once you go over a certain level of wealth, maybe you should be thinking about some kind of estate planning, whether that's the use of trusts in South Africa, whether that's the use of trusts and pensions and other sort of things outside of South Africa. One of the other ways to protect yourself against the costs of sadly passing on and all the associated problems with it is insurance. And again, this is a thorny issue because I think maybe a number of clients have had bad experiences around insurance over the years, and what we need to do is actually unpack, why is insurance something that should be considered as a part of these solutions, a holistic approach? So Lourens, you have this discussion with clients all day, every day as I do. When would life cover be something that would be considered? And what kind of solutions do you think maybe for the higher net worth individuals with cross-border assets? As we can see, there's a lot of people on this call listening in for that answer in particular. When do you think insurance is an option and should be considered for clients with those?
Well, Mark, thanks. I think there's a couple of things that people neglect to look at. So I had lunch earlier today with an ex-colleague of mine, and they're very, very hot on this particular topic. And what they do is they have an in-house professional will writer that they use. And as soon as they've written the will, they say to the client, "Now we're going to kill you." They literally say those words. "Now we're going to kill you. So now you're dead." Okay. And then they take everything that they've written that will about. They then look at all the outcomes based on jurisdiction, based on estate duty, based on this, based on executive's fee, based on master, based on accountants, based on conveyancing. They do absolutely everything. And then they look at the liquidity that exists in that estate. And they then say, "This is how much you need today, but your estate will double." And then I ask the client, "Okay, if I didn't kill you today, when do you plan to die?" "I plan to die at the age of 85. Okay, so then that means your value of your death is 4 times increased. Therefore, the cover needs to be 4 times increased, because if you don't have it, they're going to sell your family home. That's what's going to happen. End of story." And so there's 2 types of insurances. I say actually 3, but there's 2 types of insurances. I like the second one. There's one type of insurance, and you rent it like a home. Okay, you rent it. So each month I pay, and the day you stop paying, you move out. It's gone. Someone else's house. All right, it's not yours. I like the type of life cover that you own. Okay, and we're talking big ticket stuff, but this is also for people who have huge estates, typically, but where the end is predetermined. So it says already right now, I'm going to buy this insurance for $1 million. okay? But you own it, it's yours. So I put in $200,000, $300,000, for example. I own my $1 million, but the $100,000 to $200,000 is invested. So it's invested like a pension. You can put it inside of an overseas pension or a trust, and you invest it, and you can draw from it later down in life. But the $1 million is secure. And you know what? If you want to sell or you want to take all your $300,000 back, then the life cover disappears. But that's a far better way to insure an estate for me than just the regular premium every month. And then Mark, you know, we had a colleague that died at the end of last year, 2 months before. Sorry, let me just grab a water. Carry on talking.
Yeah, I think that it's an ideal opportunity to just ask one of these quick questions that's insurance related in the chat here. So Amanda was asking, I'm interested in the premium attached to protection policy. Is that something that's a monthly amount? So Carl, probably one for you. You know, how does that work for clients on that side?
So actually, Lourens hit the nail on the head. So when we sit with a client, we first draft the will, and then we do a calculation of the cost of dying. So we kill the client right then and there. We show them the actual cost, the executive fee. You know, we look at their properties, we show them their conveyancing fees, we look at the assets going into the trust, we show them the actual trust costs. And then there's other non-legal fees that we need to take into account: master's fees, property valuations and clearances, advertising costs, and other disbursement costs within an estate. So we take the client to that level where we show them the actual cost of dying, the real cost of dying, and then we've got a varying range of solutions that plugs in to solve that problem for the client. To give you some perspective, our lowest premium is 90 Rand a month. To you guys there in the UK, that's nothing. And for an Elon Musk kind of an estate, it's about 500 Rand a month. So we've got a solution for all types of clients, whether they're rich, the normal person, whether they're old, whether they've got pre-existing conditions. It's a monthly premium, and it's a policy that solves a problem for their estate.
Thank you, Carl. Lourens is back, thankfully. That would have been slightly ironic having a discussion about choking in the middle of an estates discussion. So Lourens, do you want to just wrap up what you were saying before we come to the end of the webinar?
Yeah, so I have as you know, sorry, it's still there. A bit sick today. But as you know, Mark, we have a colleague in the UK that died. I hope I'm not dying. And as soon as I'm thinking, it's like, have I got my life cover?
Have you done your will?
Have I got everything? You know, funny that. But we had a colleague that passed away sadly in the UK, and he passed away late last year. And he fell on kind of hard times. And 2 months before he passed away, he cancelled his life cover and left a young family with other people having to support them. This is a tragic series of events. So I think a long story short is you have to make provision. You know, I remember when it was COVID, my father-in-law went into hospital when it was the horrible, the Delta variant. And he was in hospital in a very small room. And the person across from him died that night quietly. This person across from him died loudly. He could hear the person dying. Whilst he's in hospital, he sends me, as sick as a dog, he started sending me emails on his letter of wishes. And then you realize how powerful the stuff is that we do in the background for clients. My colleague who runs Johannesburg, Heinrich, he had a client that he saw for a structure that would have mitigated much of his estate. He saw him prior to going up into Africa. He caught COVID in Africa in bad medical conditions, was 99, or he would have died. When he came back to South Africa, he did not see his family. He did not see anybody. He went to Jeffreys Bay to see Heinrich first. Heinrich was the first person that he wanted to see to sort this stuff out. And so for those who are lucky enough to watch this today, just if you passed away today, the question is everyone else okay? Now, if you're lucky enough to have loved ones, you know, this is the time that you actually show them how much you care. So, or else you have people fighting, feuding, you know, estates get stuck, you know, you need to plan. And that's kind of the message I think that everybody sends out. Mark, do we have any more questions?
Yeah, there's a stack more. I'm really conscious of the time though. We're just not going to be able to get through them all. So if we haven't been able to answer your question today, sincere apologies. Please do reach out to your Holborn consultant, or just reach out to us on the details that I'm going to put on screen for Lourens, and his team will be able to respond to you and help out if you've got any questions that we haven't been able to answer today. I just want to finalise today really by thanking you all very much for taking your time to join us on this webinar. If you'd like to know anything more about anything that's been discussed today, or if you have any further questions you wish us to ask in more detail, then simply reach out to Lourens on the details here, and we'll find the most appropriate person to answer the question. To all of the guest speakers and our panelists, so to Martin, Carl, Ken and Lourens, thank you all for taking the time, and look forward to seeing you on the next one.
Thanks, Mark.
Thank you very much.
Thanks, Mark.
Cheers, Mark.
Bye-bye.
Thank you, everyone.